Thank you, Mr. Chairman. Before I move on to my questions, I'd like to respond very briefly to what Senator Cruz said earlier. It is important, in my view, that the members of this committee get clarity with regard to the nominee's record. That's our job, and it's important. Now, let's be clear. Senator Sessions said in his questionnaire that he, quote, personally handled 4 civil rights cases. Some of the lawyers who worked on those cases disputed that characterization, and Senator Sessions himself, after his questionnaire was in, felt a need to file a supplement in which he clarified that he merely provided, quote, assistance and guidance to Civil Rights Division attorneys on these 4 cases. Now, if that's a distinction without a difference, I'm not sure why Senator Sessions felt the need to clarify, but I want to move on. Senator Sessions, in late November, President-elect Trump tweeted, quote, in addition to winning the Electoral College in a landslide, I won the popular vote if you deduct the millions of people who voted illegally. Now, let's be clear. President-elect Trump lost the popular vote by more than 2.8 million votes. So what he's saying here is that more than 2.8 fraudulent votes were cast. Do you agree with President Trump that millions of fraudulent votes were cast in the presidential election?
Senator Franken, I don't know what the president-elect meant or was thinking when he made that comment, or what facts he may have had to justify his statement. I would just say that every election needs to be managed closely, and we need to ensure that there's integrity in it. And I do believe we regularly have fraudulent activities occur during election cycles.
Well, the Department of Justice is tasked with protecting voting rights and prosecuting fraud. So if millions upon millions of fraudulent votes were cast, I would imagine that the next Attorney General would be quite concerned about that. Did the President-elect tell you anything about what caused him to come to this conclusion?
I have not talked to him about that in any depth, or particularly since the election.
Mm-hmm. So he didn't share any evidence of voter fraud with you, because I would imagine, as the man who wants that he wants to make responsible for combating fraud at the ballot box, that he would want to make sure that you had all the evidence necessary to take action and to protect the vote. So he didn't do that, evidently. Before we move on, I should note, for the record, that state election and law enforcement officials surveyed in mid-December found virtually no credible reports of fraud among the nearly 138 million votes that were cast, and no states reported indications of any widespread fraud. What's truly troubling about this, I believe, are these bogus claims of voter fraud, is what they're routinely used to justify voter suppression. And thanks to the Supreme Court's disastrously decided Shelby County decision, which gutted the Voting Rights Act, it is easier than ever before for states to make it harder for people to vote. Now, Senator Sessions, you have a complicated history with the Voting Rights Act. 10 years ago, when voting rights was a bipartisan issue, you voted to reauthorize the Voting Rights Act. Everyone did, passed 98-0. But you have also called the Voting Rights Act, quote, an intrusive piece of legislation. You have complained that the Act's pre-clearance requirement unfairly targeted certain states, and you have said that there is, quote, little present-day evidence that state and local officials restrict access to the franchise. You said that the Voting Rights Act has, quote, eliminated that discrimination. Well, Senator, after the Shelby County decision, which you celebrated, states began testing the limits of what they could do, and in many cases, citing the risk of so-called voter fraud as a justification for their actions. Now, that's what happened in North Carolina, for example. Just a few months after Shelby County, The state enacted one of the nation's strictest voter ID laws and enacted other restrictions. Without any evidence, the state described these changes as necessary to prevent fraud. Well, the courts disagreed. North Carolina's restrictions were challenged, and in July, the Fourth Circuit found the primary purpose of the restrictions wasn't to fight fraud, but to make it harder for black people to vote. Here's what the court said, and I quote, "The new provisions target African Americans with almost surgical precision. They constitute inapt remedies for the problems assertedly justifying them, and in fact impose cures for problems that did not exist." Senator, do you still believe that there is little present-day evidence of states restricting access to the franchise? And if you do, what do you think the Fourth Circuit got wrong when it found that North Carolina targeted black voters with almost surgical precision? Do you accept that North Carolina was targeting African American voters, but not believe that it was engaging in discriminatory conduct?
Well, you cannot create laws designed to inhibit the right of any class of citizens to vote. And so if the Fourth Circuit found that and there's a factual basis to support it, then any law that's passed would be subject to being either eliminated or altered. So I support your concern that laws of this kind cannot be used for that purpose. I do believe not long ago, the Supreme Court did uphold voter ID laws, but there are ways to do it and ways probably you cannot do it. So I am not familiar with the details of the North Carolina law, but you are correct. Any finding that's sustainable, that there's a racial animus in the passing of a law that would restrict voting, that law could be unsustainable.
Now, North Carolina is one of the states that would have been covered by pre-clearance, was it not?
North Carolina states would be, of course.
It would have been. So in other words,
I would just suggest that Section 2 allows all the remedies, and that's what I suppose they filed the action under in this case. It's just not a pre-clearance question, and that pre-clearance policy is intrusive, and as the Supreme Court has said, and I didn't mean that in any pejorative way. I was asked, do you believe it's intrusive? Is that correct? I said it is intrusive, but the Voting Rights, it said this in 1986, but the Voting Rights Act was absolutely essential to reverse the problems that we had in the South of systemic voting.
Chairman, let me just respond to that, please. Okay, here's the thing.
Well,
okay, because we had this debate after Shelby, and Chairman Leahy tried to introduce something to substitute so that we could have pre-clearance again, which was fought by you. The whole point is that Section 2 of the Voting Rights Act, you're right. But how many years after North Carolina did that? So how many times, how many elections were conducted in North Carolina where African Americans' votes were suppressed? That's why you need pre-clearance. And as soon as Shelby came down, you saw Texas, you saw North Carolina go, oh, good. Now we can suppress votes. That is the reason you have pre-clearance. And that is the reason that you can't rely on the district court, the circuit courts, to rule.
Mr. Chairman, I voted a few years ago for the Voting Rights Act extension for 25 years. It included pre-clearance in it. We all knew at that time that the Supreme Court would probably take up a case before long that would have wrestled with the question of whether there's a sufficient basis for the extraordinary remedy of requiring only a few states in the country to have every even ministerial act like moving a voting precinct to seek the permission of the Department of Justice first. The Supreme Court found that that no longer could be justified. The Supreme Court decided that we did not have to have pre-clearance. But Section 2 of the Voting Rights Act allows these kind of challenges that Senator Franken is talking about. That's what was brought in North Carolina. That's what's being litigated today. And the court there did, in fact, find that the voter ID law was improper, as I understand it. So I believe we proceeded in a lawful fashion, and I did feel, in one sense, that it was a good feeling that the Supreme Court had concluded there had been substantial improvement in our area of the country, the South of the country, in voting rights, sufficient that Section 5 could no longer be justified. But I voted for it.
Thank you, Mr. Chairman, for your indulgence. As Justice Ginsburg said, when an umbrella means you don't get wet when it's raining, and you don't take the umbrella away.